Thank you for coming by. This is the American Project. Please be sure to like the video and subscribe. I really appreciate it. I have a second channel I set up. Look in my description. Go check it out and subscribe on that channel too for me. I really appreciate it. All right, let's get started. An immediate review should be had, is what the judge said in the case with Harrison Floyd and Fani Willis. Harrison Floyd's a co-defendant in a Georgia racketeering case, and his lawyers have put in for an appeal, and it has been granted, which is a big deal. So let's take a look at it and see what they said. A co-defendant in a Georgia racketeering and election subversion case against former President Donald Trump will be allowed to immediately appeal a series of trial court rulings against him in a Georgia Court of Appeals. Bolton Superior Court Judge Scott McAffee on Monday granted a certificate of immediate review, allowing Harrison Floyd, the former leader of Black Voices for Trump, to request a hearing from the higher court about his procedural motion to dismiss the case. Now, this fella is the only one that landed himself in jail, which is unbelievable. So he's being treated pretty, not very good, pretty bad, actually. So, and there's not much on him for some reason. He hasn't been covered that much. He should be covered a lot more. McAfee has on several prior occasions denied arguments advanced by Floyd that Fulton County District Attorney Fani Willis was operating beyond her jurisdiction when her office began an election-related investigation and subsequently when the charges were filed. Related coverage is as follows. Floyd has been pressing the issue since October 2023, arguing Willis's office did not have authority to investigate or for presentment authority to bring election-related charges against the defendant absent a referral from the state election board. Okay, so that's the big deal. The state election board did not request it, so she didn't have authority to start investigating it and bring the charges, is what he's saying. State replied to those arguments last November, and Floyd's attorneys replied to the state last December, court documents show. Okay, so the court first ruled against Floyd's arguments regarding the remit of Willis's power on January 9th of this year, finding that Willis did in fact have concurrent jurisdiction with Peach state election officials, and that she did not need a referral from the board to pursue election subversion charges. All right, there's a lot of problems in this case. The paperwork's not done right. There's a lot of funny business going on. You know about what's been going on with her, and they're trying to disqualify her and everything else. So there's just more trouble with this case. It wasn't handled properly. In turn, Floyd's attorneys made their first request for permission to appeal to the higher court on January 12th, with an alternative request for the judge to simply reconsider his ruling in the district attorney's favor. Earlier in March, the trial court dispensed with the defense motion to reconsider, tersely ruling against Floyd without discussion in a one-page order and reaffirming the early January order. Last week, Floyd tried yet again, filing a second motion for certificate of review in response to the denied motion for reconsideration. This time, McAfee decided to take the issue off his own docket. McAfee, the requested motion is granted. And he goes on to declare his January 9th order to be of such importance to the case that immediate review should be had, citing language from the relevant section of Georgia law on direct appeals. Okay, so this is a really big deal. It's been granted, so keep an eye on this case. Things could change for the better for the defendants. The issue now facing the Georgia Court of Appeals is technically procedural, but a question of applicable law bearing down on the facts, specifically should the higher court take the case. It will have to determine whether McAfee properly applied the law in an instance where two statutes are arguably, according to the defense, in conflict. To hear the defense tell it, an election-focused statute overrides the general provisions of the statute outlining grand jury procedures. The district attorney's office and the trial court have both previously said there is simply not any conflict of the law here, rendering irrelevant for now the uncontested issue of how Willis acted to secure the sprawling RICO indictment in August of last year. Okay, he goes on to say, it is undisputed that no referral was sought nor granted. Floyd's latest motion reads, despite the court's explanation of harmony against these statutes to hold the district attorney holds concurrent jurisdiction with the SEB and that a referral from the SEB to the district attorney is not necessary in election-related cases renders 21-2-35 absolutely meaningless and superfluous. Under Georgia court rules, the defendant will have 10 days from the date the certificate of immediate review was issued to file his application for an interlocutory appeal. Then the Georgia Court of Appeals will have 45 days from the date the application was filed to issue an order granting or denying consideration of the appeal. Okay, so it's coming pretty quick here. The case will, however, still move forward in McAfee's court. At the start of this case, Floyd was the only one among the original 19 co-defendants to be jailed for days after post-indictment surrenders because he did not negotiate a bond in advance. After securing his liberty, Willis sought to revoke the bond and throw Floyd back in jail over social media posts. McAfee declined to do so last November. Okay, so they got a sharp eye on him to keep watching. This is what I was talking about earlier when we started, that he was thrown in jail. And Fani Willis keeps on trying to get him back in there, as you can see. Floyd's formal permission slip is the second certificate of immediate review granted in the case so far. Progress in the case was stalled since January on a motion to disqualify Willis, which was granted and denied in part earlier this month. McAfee allowed the defense to immediately appeal that ruling as well. So this could overturn the entire case. This is a big deal. I don't know why I'm not seeing more of it, but I went ahead and put it on my channel here so y'all could hear about it, and I'll keep an eye on it. So thank you for coming by. Please be sure to like the video and subscribe. I really appreciate it. Check out my second channel. Have a great day. God bless.